We have a very intimate setting here today, so if anyone wants to come down here, we'd love to have you. We heard a lot this morning about the risks of offshore transactions and working in the offshore world. We are now going to talk about some of the rewards that are available under our various whistleblower programs. My name is Scott Oswald, and I represent whistleblowers, mostly insiders, individuals who are working for funds. They work for trading houses. They work for corporations, both in the United States and outside the United States, and they have discovered wrongdoing. And they are reporting it, and they are reporting it now to a whole host of regulatory bodies. The difference is since 2010, they now have the opportunity to receive real rewards. So we're going to talk about 2012. It was described by journalists as the year of the whistleblower. In 2012, there were more rewards that were issued to individuals than in any year in our history. We're going to talk about the big incentives that are available to whistleblowers, and we're going to talk about the U.S. bureaucracy and how the bureaucracy for the first time is now supporting whistleblowers who are coming forward. Okay, first, just a few things. Corporations have finally responded. GlaxoSmithKline came forward and self-disclosed. They paid a $3 billion settlement on a drug that they received a profit of just over $11 million for. So they gave up about 1/3 of the total amount. We'll see what the whistleblower who came forward prior to their self-disclosure, what he received. The key for corporate America is the fact that they have to be more diligent, because individuals, to the extent that they have information, now have the opportunity for the first time to receive significant rewards. So the rise of the whistleblower programs. Prior to 2006, there was only one significant whistleblower program in the United States. It was the False Claims Act, passed in 1865, reinvigorated in 1986. In 2006, we had the IRS whistleblower program. In 2010, the Dodd-Frank program. We'll talk about that. And, of course, the False Claims Act itself was fine-tuned by Congress in 2009. We'll see how those changes have just begun to work their way through the system in 2012. The Dodd-Frank legislation. Most people who watched any of the presidential debates can remember that Mitt Romney said that he was going to repeal the Affordable Care Act on day one of his administration. Most people do not remember that there are actually two statutes that he said that he would repeal or work to repeal on day one. The second was the Dodd-Frank Act, which was passed in 2010. It created the whistleblower offices at the Securities and Exchange Commission and at the CFTC. These reward programs allow an individual who comes forward to receive a percentage of the total so long as they disclose over $1 million of between 10 and 30%. The IRS Whistleblower Program. We have heard a lot about the Bradley Birkenfeld Award last year. We'll get to that later on. But the IRS Whistleblower Program has seen more tips over the last 3 years than it did in its entire history of disclosures prior to that point. An individual can receive between 15 and 30% of the total to the extent that there is a recovery of $2 million. It recovers tax underpayments. It recovers any kind of recovery from the Internal Revenue Service. And it does not matter whether or not the violation was intentional or in fact was accidental. No statute of limitations for fraud. Okay, the Department of Justice programs. The most important is the False Claims Act. And the False Claims Act, as amended in 2009, is now much more robust than it was. It covers any kind of fraud that touches upon federal government funds. And it allows an individual not only to file a claim with the Department of Justice, but to then pursue a claim on their own to the extent that the Department of Justice does not proceed. It allows individuals to receive up to 30% of the total that's recovered by the Department of Justice. Bank fraud rewards. We've seen a reinvigoration of a statute that was passed in 1986, FIREA. This is the statute that is being used by the U.S. government to recover funds that were lost as part of the financial implosion in 2008 with large banks, the most recent of which is Wells Fargo. And individuals under this statute are also allowed to pursue claims on their own to the extent that the Department of Justice chooses not to proceed. Okay. One of the important things to know about whistleblowers, for those of you who work for offshore funds or offshore transactions, is that most individuals do not want to become whistleblowers. When they come to me, they say, look, I'm making X amount of money per year. I might receive a reward later on. Maybe it's 8, maybe it's 10 years down the road. Do I really want to give up my career for this opportunity? And thus, for corporate America, for funds, for individuals who are in this world, it gives corporations and entities a remarkable advantage for real compliance. And we're going to talk about that in just a minute. The key, though, is to align corporate culture with the incentives that are provided by our statutes, our whistleblowing statutes. One of the things that I thought was important, and I wrote an article last year on this, was how corporate America really saw whistleblowers prior to really the last 10 years. And this is a quote by James Roche at General Motors. And what you can see from this quote is that at least at General Motors in the 1970s, whistleblowers were not lauded, were not encouraged, and often were retaliated against. And this really occurred throughout not only corporate America, but also how the financial world looked at whistleblowers through the 1980s. What we really see, though, is that corporations are starting to realize that there is a consequence to not aligning their corporate policies to the realities of our whistleblower statutes. We're seeing corporations for the first time implementing compliance in a way that is starting to encourage individuals to come forward and report wrongdoing in the workplace in particular. And these powerful incentives are beginning to work. We're going to see how that is playing itself out in just a moment. Okay. The thing that's the most important is to know is that these statutes are now working. For example, in 2012, we see that whistleblowers for the first time are receiving huge amounts. $700 million under the False Claims Act, the largest whistleblower reward under the False Claims Act, and of course, Bradley Birkenfeld's $104 million received in August of last year. And I thought it was important because to look at precisely what the Internal Revenue Service said in its award letter. And here's what it said. Birkenfeld provided information on taxpayer behavior that the IRS had been unable to detect, provided exceptional cooperation, identified connections between parties to transactions and the methods used by UBS-AG, and the information led to substantial changes in UBS-AG's business practices and commitment to future compliance. The actions against UBS AG and the attendant publicity also contributed to other compliance programs. We heard about that this morning. The Internal Revenue Service has had $5 billion come in as part of these programs. Each of these factors could support an increase in the award percentage above the statutory minimum. This was the award letter that Bradley Birkenfeld received from the Internal Revenue Service in August of last year. Okay, we've also seen the first payout under the Securities and Exchange Commission program. Now, it wasn't terrifically large in terms of total dollars, $333,000, but Sean McKessie, who is the head of the whistleblower program, has said that they are receiving, on average, about 7 good tips a day. They received 3,000 tips last year, and he expects this year that there will be between 10 and 15 of these awards at a minimum, and that is only going to increase over time. The key here is the quick turnaround. In some of these, as little as a year. Here was the first, the announcement in the Wall Street Journal on August of 2012, interestingly enough, just days after the announcement of Bradley Birkenfeld's award. Okay, so what are we seeing? We're seeing larger rewards. We're seeing more than at any other time in our history in 2012. The IRS, in fact, has made 128 payouts, recovering more than $500 million under its program. Importantly, all but two, the two under the current program, were quite small. But 2012 marked the first time when there were two very large awards. Bradley Birkenfeld's award, there was a $40 million award as well that was issued anonymously. And here's what we see. These are the numbers. As you can see, in 2012, the Internal Revenue Service received 342 tips. The Securities and Exchange Commission, 3,001 tips. And this is what I think is fascinating. The SEC received tips from 49 countries. Not just from the United States, not just from contiguous countries, 49 countries they've received tips from. Agencies now, for the first time, are encouraging whistleblowers to come forward. Most people do not know that what reinvigorated the False Claims Act was one provision in 1986. And it was the provision that prohibited the Department of Justice from automatically dismissing out claims. They were required to pay rewards under the False Claims Act. Now, over the last 20 years, the Department of Justice has seen for the first time the benefits of the whistleblower program. The U.S. Attorney's offices, just to give you an example, on health care fraud cases, are allowed to keep 3% of the total amount that is recovered by each U.S. Attorney's office. In some of these offices, it is as much, it funds the office for the entire year, not just their civil division, but their criminal division as well. And in a time of sequester, these monies are not, because they are not appropriated by Congress, are not affected by the sequester at all. It is literally keeping some of the U.S. Attorney's offices humming, notwithstanding the sequester. This is a very interesting graph. Look at the total number of cases under the False Claims Act and the total recoveries under the False Claims Act. And what's important about this graph is this. The total dollars here for 2012, larger than in any year previously. And look at the total amount in the healthcare area here. And of course, a clear reliance on whistleblowers. That's where these cases are coming from. Back in 1987, when the year after the False Claims Act was reinvigorated, A vast majority came from the Department of Justice's own investigative work. Now look at 2012. It's a small amount. Most have come from whistleblowers who have come forward and filed under the qui tam provisions of the False Claims Act. These agencies, for the first time, are starting to work together. For example, the SEC has FBI agents who are embedded within the SEC. They work closely with the SEC. The IRS has IRS agents that are seconded to the SEC and vice versa. When my office goes into a relators meeting or a whistleblower meeting with the government, we now have officials from a whole host of agencies. And last month, for the first time, I had a case where we had officials from the Canadian government. They were sitting in a relators meeting wanting to obtain information about the disclosures that the individuals were making. The SEC has created offices now that are designed to support the Whistleblower Office. One office, the Foreign Corrupt Practices Act office, is looking for instances where there are potential violations of our FCPA statute in particular. So in addition to the positive incentives that are now being provided to whistleblowers, what is also important to know is that there are protections for whistleblowers as well. And in particular, that prohibit retaliation. So the whistleblower comes forward, he discloses the information, and now our laws protect that individual from any kind of adverse action. And the person does not have to, as we'll see in a moment, be an employee of the entity. Okay, let's look at some examples. This is a case, the first one, Vinoy v. Celanese, that was issued by the Administrative Review Board, a little-known appellate body within the Department of Labor. And this body is responsible for interpreting the protections under 19 U.S. whistleblower statutes. Mr. Vinoy was an employee of Celanese Corporation, and he discovered that they were violating tax laws as they related to their health care plans. He downloaded almost 5,000 documents from the corporate server containing Social Security numbers, payout information, financial information, and he submitted this information to the Internal Revenue Service as part of a whistleblower claim. He was fired as a result of the Celanese Corporation said from downloading this information, that he did not have the authority to do so. The Administrative Review Board found that, in fact, under the Sarbanes-Oxley Act, what he had done was protected conduct, that it was embraced by the statute, that the statute encouraged that because of the fact that, in part, he was disclosing the information to the Internal Revenue Service as part of its whistleblower program. Sylvester v. Paraxel. Now, for the first time, under our whistleblower laws, you don't have to be right. Indeed, you do not have to be specific, identifying a specific provision of the law that is violated. All you have to have is a good faith, reasonable belief. And if you disclose it internally, the whistleblower discloses it, he's protected from retaliation. More employer conduct now is actionable under our laws. It used to be that you had to have a relationship of privity with the target in order to come under the protections of our laws, meaning you had to be an employee of the corporation, you had to have some sort of contractual relationship, either expressly or impliedly. Now you do not. Fernandez v. Halliburton is a case where the individual was not, at the time of the disclosure, an employee. The Administrative Review Board found that under the circumstances, that person was protected. Fernandez v. Navistar. When Mr. Fernandez went to the SEC, he was no longer an employee of the corporation, Navistar filed suit in a little county outside of Chicago, DuPage County, to prevent him from cooperating with the SEC. The Administrative Review Board found that that was retaliation, that he could receive recompense for the loss of any employment opportunities that came as a result of that lawsuit, and embraced a damages structure for him in the millions of dollars. Now, you do not have to be an employee to have the protections of our anti-retaliation statutes. I pulled an excerpt from the Fernandez case because I just wanted you to see how broad this is. Accordingly, as Menendez is the most recent expression of the Board's approach to interpreting the statutory language of SOX, I find the Board's most recent guidance compels me to find that an alleged adverse action need not be employment-related to support a cognizable claim under the Sarbanes-Oxley Act. Okay. Our anti-retaliation provisions in our laws extend beyond our borders, beyond the United States, so long as there is at least some effect on U.S. commerce. And we're going to talk about the Dodd-Frank Act and how it expands the reach of our anti-retaliation provisions. Importantly, the Supreme Court came out with a decision in 2010 called Morrison v. National Australia Bank Limited. And one of my colleagues who represents relators in false claims action said that he appreciated when the Supreme Court came out and restricted some of our whistleblower statutes, because usually the reaction in Congress was swift to then extend those statutes more broadly even than they were beforehand. In the wake of this decision, the Congress enacted the Dodd-Frank Act. And here's what's important. Conduct occurring outside the United States that has a foreseeable and substantial effect within the United States now is covered under the Dodd-Frank Act. Section 929PB specifically and expressly extends the Investment Advisors Act beyond the borders of the United States. All that is required is that it have some effect on U.S. commerce. The individual does not have to be in the United States. The individual does not have to be a U.S. citizen. The transaction does not have to occur within United States borders. All that is required is that there is a substantial effect and foreseeable effect within the United States. Another good example, Dos Santos v. Delta Airlines by the same body that was responsible for the Fernandez case. This was a man who was not in the United States. He was in France, in Paris, working for Delta Airlines on a flight and flights located in Paris. And what he disclosed constituted fraud in Paris. But still, the administrative judge found that because there was an effect on U.S. commerce, that our anti-retaliation provisions applied. There are anti-retaliation provisions in all of the acts that are listed here. Any kind of disclosure that relates to fraud on the government, bank fraud, commodities fraud, foreign bribery, and accurate accounting, all now are covered by our anti-retaliation laws. And remember, There does not have to be privity of contract. There does not have to be an employee relationship in order for these provisions, these protections, to apply. Okay. Now, the first thing we have to look at is the statute itself. Does the statute say that the provision covers foreign activities? Each one of the ones we went over before specifically state that any kind of activity that has at least a substantial effect on U.S. commerce will be covered. Under those circumstances, they will have extraterritorial effect. Okay, 2012 was not an anomaly. We're going to see larger awards. It shifted the federal government's response to protect whistleblowers and provide them with greater rewards. And what we see is that although President Obama has had some difficulty in appointing members of our judiciary, especially the courts of appeals, where he's had the most effect is on these administrative bodies. At the Department of Justice, at the Department of Labor, the Administrative Review Board. These are bodies, and of course at the Internal Revenue Service, these are bodies that are making regulatory law that is expanding each one of these statutes, both the rewards provisions and the anti-retaliation provisions, to cover activities that are occurring abroad. In addition, Congress has passed additional protections for whistleblowers, the most recent of which is the Defense Contractor Whistleblower Act and the Contractor Whistleblower Act, which go into effect on July 1st of 2012. These provisions apply to individuals so long as they work in any way on a contract with the United States government. The Defense Department, Department of State, NIH as an example. In 2012, we saw, for example, the first case under the amendments to the False Claims Act anti-retaliation provisions, a case called Huang versus the University of Virginia. And in that case, Dr. Huang complained about the fact, or disclosed the fact, that the university allegedly was taking grant funds from certain contracts and using them for other purposes. And the university brought a motion to dismiss, was denied. A motion for summary judgment was denied, and a jury in Charlottesville, Virginia issued what was then the largest verdict since the Fraud Enforcement Recovery Act for Dr. Huang, finding that he had engaged in protected conduct on that NIH contract. So for the first time, what we're seeing is these anti-retaliation provisions being embraced by juries in the United States as well. Two important cases from just very recently. The first is Wiest v. Lynch. This is a case where the U.S. Court of Appeals for the Third Circuit found that the Administrative Review Board had the authority to interpret the Sarbanes-Oxley Act in the broadest sense possible. SEC v. Gruss, finding that the SEC had an argument for extraterritoriality under the Investment Advisors Act. Just within the last month, we have a new SEC commissioner, Mary Jo White, and I think that it's important to note that she is a former prosecutor, someone who has been responsible for prosecuting some of the largest white-collar fraud cases in the Southern District of New York. She has indicated that she has made, or is going to make, the whistleblower program a priority at the SEC. It already is, and she is going to provide them with additional support. The Internal Revenue Service. The IRS has been under significant heat over the last 2 years for not issuing the kinds of rewards that some in Congress thought they would. Of course, that all changed in August of last year with the Birkenfeld award, but the IRS has indicated that they are going to be issuing more rewards of that size in 2013 and 2014. Okay, so what's corporate America to do under the circumstances? Well, the key is to embrace the whistleblower, to embrace compliance, and then to report. And we heard some of this morning. The IRS now has programs that will give individuals amnesty and corporations amnesty for self-reporting. So does the SEC under certain circumstances. All right. One of the important things to know is that if an employee is a licensed professional, let's say and they come upon evidence of fraud or wrongdoing, they may have an ethical obligation to report. Sarbanes-Oxley and Dodd-Frank require any investment professionals who are regulated to report instances of violations of the Sarbanes-Oxley Act or violations of any of the provisions that relate to the exchanges on which they work. They have an ethical duty to do so. And that's, in those situations, employers have to be even more careful about what they do, because if they retaliate against the individual, now under the SEC rules, that individual has the right to disclose to the SEC and receive a reward where they otherwise might not. So what do corporations, what can they do? Well, compliance, of course, helps. And what we're seeing from our end is, for the first time, corporations being serious about compliance, to embrace whistleblowers when they come forward, and in doing so, avoiding regulatory actions for disclosing information to an enforcement body. And a good example is the IBM open door grievance policy. It's been the model for other corporations. It was instituted in 2009, and it is something that the Society of Human Resources Management and other compliance organizations are touting as the model. Now, the key, though, is that the policy itself, when it is instituted, that whistleblowers are embraced. So, what are the keys? When an individual comes forward, to let them know they've been heard, to investigate a disclosure carefully, to follow up with the whistleblower, explaining reasons for actions or non-actions that the corporation or the fund is taking, and to, of course, ensure that the individual is not retaliated against. So in sum, 2012 was, I think, correctly described as the year of the whistleblower. It is the turning point year for all of our whistleblower programs. They're going to increase in the number of awards, the size of the awards given the incentives that are available, and corporations for the first time, I think, are acting responsibly and appropriately in embracing whistleblowers who are coming forward. With that, I'm happy to answer any questions. Yes?
Are you familiar with the IRS whistleblower program? I imagine that was touched upon in some of these slides.
Yeah. I am.
And what has your experience been with respect to submissions and the IRS's decision to either pursue claims or not to devote resources, and how they decide which cases to pursue and which ones not to pursue?
Well, you know, for years, what would happen is that you would file your whistleblower disclosure package, and they would handle them in the order they received them, literally. And you could wait months and months for something to happen. Since 2012, they created a triage program. They brought enforcement people over to the whistleblower office, which they did not have before, subject matter experts. And the first thing that they are doing is they are channeling those cases to these subject matter experts that they've seconded from other divisions. And what it's meant is that we're seeing these cases moving much more quickly into enforcement. So the process of what happens in the whistleblower office, in terms of what happened before, they would sit in an office, they would be opened in the order in which they were received, and maybe they would be channeled off to enforcement if someone thought they were interesting. Now those cases are being handled within about 3 months. And in most situations, within 6 months, we're receiving either a call from a subject matter expert saying, I want to talk to you about the case, or you're getting a declination letter saying, we're not going to pay out an award.
The process could have been several years.
Could have been several years, that's right, before you even get notice. Now, it can still be many years between the time the subject matter expert gets the case and the case is then moved to audit. But at least you know what's happening in the case.
Right. I remember, I think it was a year or two ago, there was a change in some regulation or some law that allowed some of the proceeds from the whistleblower program to be used to hire additional staff to follow those things because they were simply overwhelmed. They couldn't even get to them.
Right.
Is that correct? Has that been dealt with?
It has. And I think the real challenge for the whistleblower office now is cooperating with the whistleblower. One of the hardest things that we have, those who represent whistleblowers, is the difference between what happens in the False Claims Act world and the SEC world and the IRS. I'll give you an example. When we file a suit under the False Claims Act, we have a regular interchange with the Department of Justice and with the investigators that are handling the case. Sometimes they will gather hundreds, maybe thousands of documents, and they'll share them with the whistleblower. They'll ask them what the significance of a particular document is, or they will talk about what they have uncovered as part of their investigation. That helps them to get to the best information that might relate to the underlying fraud. The IRS does not do that. And that's the most important difference.
Is there a prohibition against doing that?
There's a prohibition, well, there's an escape hatch. They have a prohibition against sharing taxpayer information with outside third parties. Now, there's something called 6103N agreement. This provision of the law allows the IRS to enter into an agreement with a third party to share information. The problem with the IRS is they have not entered into any of these agreements yet. And so that's the real challenge. For us in the whistleblower bar, where we're used to an agency in which there's a cross-pollination of information, and the IRS where it's all one way. And that's the real difficulty. The other problem on the IRS side is, and rightly so, is that the process takes longer. There's the investigation, there's the audit, there might be the appeal of the determination. The IRS now takes the position that the individual whistleblower cannot receive the monies until the appeal period has run. And that can be several years, depending upon if the person has made the payment.
It's 2 years after the last payment.
Precisely. So one of the changes in the regulations that we're hoping that they will consider is an interim payout structure. When they know that the likelihood that the taxpayer is going to request a refund, they know that the likelihood is very low, to at least notify the whistleblower that they're likely going to get paid. And a good example is in a criminal prosecution. If an individual receives, as part of their plea, they agree to pay the Internal Revenue Service a certain amount of money, they're not going to then come back and sue the Internal Revenue Service for those monies. And in those situations, the IRS ought to be issuing notice of at least an interim determination to individual whistleblowers so they know where they stand. We're hopeful that that's going to happen.
Isn't there a similar situation where the IRS can have the taxpayer voluntarily enter into a voluntary settlement, and they've waived their 2-year appeal process. So, so it is immediate?
And in those cases, there should be an immediate award of payment. The IRS takes the position that until they have the statute has run, the 2 years has run, they will not pay out the monies. And that's one of the changes in the brand new regulations that were issued here just last month, and some of the comments that whistleblower lawyers have provided to the IRS. There ought to be at least a determination of what the amount is under the circumstances. At least notice to the whistleblower, hey, we've entered into this agreement with the individual, and you're likely to receive a reward for this amount, whatever the amount might be.
And I have one last question.
Sure.
Prior to 2012, taking what you said at face value, when the IRS or the Franchise Tax Board of even state would sit on a claim for several years, they've in many cases blown the statute of limitations. They had a claim that was collectible when they received it, and they sat on it so long that they lost the right to enforce it without the money. So is that being minimized now in great part based on the change you mentioned that occurred last year?
That was part of the hue and cry from Congress, that whistleblowers are coming forward with actionable information, and not only was there a statute of limitations on a recovery, but there was other criminality that was occurring during the interim. Because oftentimes, tax violations are not occurring in a vacuum. I mean, they're occurring along with other kinds of criminal activity, which if there's a parallel proceeding and the whistleblower is involved there, the whistleblower might not receive a reward. So in many of those instances, that information then remained in the envelope, unopened by the whistleblower office for some time. Now with their new triage program, they're immediately getting to that information. And they say, Steve Whitlock has said, that he is using the resource of the IRS to send that information out to other investigative bodies, other investigative agencies, to investigate the underlying criminality as well. And in those situations, the whistleblower should receive part of whatever is recovered as part of that parallel proceeding, what's called an alternate proceeding. They should receive it because the information came from the whistleblower office and is directly related to the whistleblower's disclosure. So the hope is that over time, that the Internal Revenue Service is going to embrace the whistleblower office as other agencies have embraced their whistleblower offices. The Internal Revenue Service, they didn't necessarily want to have a whistleblower office. It was thrust upon them. And so I think that in part has led to a culture where they see the whistleblower office maybe as not as robust a function as it could be. You're welcome. Question?
Can I give you a scenario first? You tell me whether it would be captured under the sort of whistleblower program. Let's say you have a major bank that operates in the United States and globally, and they have a third prosecution agreement, and they've made commitments to that agreement, what they're going to do over a period of time. And while that might be happening in the United States, it's not happening globally. And there are, say, compliance or risk protection that are trying to obtain additional resources to be able to meet the commitments that were given.
Siri
And
not
when
available.
they put those
Connect to the
proposals
internet.
forward, they just get right. Because that touches on the US, would that be covered under this? Should those people, those employees, go to the US in some way to address their concerns?
The answer is without a doubt. Because of the fact that there is a specific agreement in place where the bank has agreed to certain compliance, to the extent that an individual is making a disclosure that relates to that agreement, there is no question that that has a substantial nexus to the United States.
Where should they go?
Well,
How do they deal with that? Because they're not in the US, they're outside, they're in 3 different countries.
well, in all likelihood, that is going to be a violation of Section 806 of the Sarbanes-Oxley Act. And what they would do is they would file a complaint with the Department of Labor's Office of Safety and Health Administration within 180 days. If their employment was terminated within 180 days of that event, or in U.S. District Court under Section 922 of the Dodd-Frank Act within 3 years of the date of their termination, or 4 years if it was intentional by the bank.
They don't have any direct proof. I mean, there are 3 individuals that have said the same thing. We don't have the resources to use it. More people spend more money, but there's no proof.
But direct proof is not required in the United States. We put people to death every day in this country on circumstantial evidence. Direct proof is not required. All that is required is that there is some evidence of intent. And under the Sarbanes-Oxley Act, the standard is the lowest standard under our whistleblower protection laws. All that the whistleblower must demonstrate is that it was a contributing factor. And his disclosure was a contributing factor in his termination. One judge, in a concurring opinion on the Administrative Review Board, has described that as, and likened it to one drop in a teacup. And then the burden of proof shifts to the bank to articulate by clear and convincing evidence that they would have taken the same action notwithstanding the whistleblowing. It is an extremely high standard, a clear and convincing evidence standard, and it is rarely met at the Department of Labor. So that kind of situation comes directly under the ambit of Section 806 of the Sarbanes-Oxley Act. Question?
A follow-up from that scenario, and I know nothing about the scenario that's been referred to, but to what extent are there any kind of confidentiality protection of the reportees? Because in any kind of circumstance, we're seeing the names of the people in the actual cases. Is that always the case for a whistleblower, that they'll end up on next year's slides in offshore, or can whistleblower, and apologies for missing the first part of the presentation if this was covered, the one downstairs ran off. So is there any kind of anonymity afforded to whistleblowers, or once you blow the whistle, can your name come out in the near future, in the next few years? How does that work?
All of the reward statutes allow you to one degree or another to remain anonymous. The Internal Revenue Statute, in fact, requires it. The target never knows who it is that has come forward. Birkenfeld himself decided to disclose his name, but the other award that the IRS made last year of $40 million was to an anonymous individual, someone who did not want his name disclosed. Same with the SEC. And in those situations, the only chance that the individual's name would be disclosed is if the SEC brought an enforcement action and they needed the individual as a witness. But the SEC, of the tips that it's received, the total prosecutions that it has proceeded on, 99% are in fact settled. And in those situations, the whistleblower's name is never revealed. Never revealed. Under the False Claims Act, an individual has the ability to bring a claim as a John Doe. Now, it complicates various other aspects in his ability to maximize his reward at the top end, but there are ways in which to shield the individual's identity through the process. So all of these provisions provide for anonymity. Now, there is one important exception, and that is under the employment provisions. So let's say that the individual is not just saying, look, I want to share in a reward, but I want to see damages for the fact that my career has been affected. Mr. Fernandez, Mr. Menendez. And they are coming forward not to receive an amount of the race, the amount of the award, but rather to receive damages for lost income, an effect on their reputation, as an example, for other damages. They must identify themselves in order to do that. But on the reward side, all of these statutes provide for anonymity in most instances.
That would be critical. That's the concern of these people. Executed in the jurisdiction they were in and wouldn't have the protection of the US.
They have the ability to do that, to do exactly that. Now, obviously, if you are anonymous and your situation that you just raised with the compliance professional at the bank, showing that the bank knew about the disclosure, if the person is anonymous, can be challenging. Because the bank is going to say, we didn't know who made the disclosure. We, in fact, it was anonymous. We didn't know. So there are situations where a compliance professional will want to disclose information. And there are all kinds of reasons to do that. One, if there's a compliance audit or prosecution, they can say, look, they planted their flag. I disclosed this a year ago. And if they do that, all of the regulatory bodies are going to factor that into their considerations. And in most instances, to the extent that a compliance professional does that, they are going to be immune from prosecution because they have disclosed the information internally. That's precisely what the Dodd-Frank Act requires, and it's what the Sarbanes-Oxley Act requires. In other situations, under the SEC rewards program, if an individual discloses internally, they get a 5% bump. They will go from, let's say the award would be 20% to 25% because they have disclosed internally. This is the grand compromise of the regulations last year. Industry wanted there to be a requirement that whistleblowers disclose internally first before they could disclose externally and receive a reward. So the compromise was, unless you are a licensed professional, that you were not required to disclose internally first, but that you receive a larger reward. Again, the thinking here is it gives the corporation an opportunity to do the right thing, to meet their compliance obligations. Any other questions at all? I want to thank you all for coming. It's been my privilege to be here, and if you have any other questions, I'm going to stay here for a few minutes, and I'll be available by email and, of course, by telephone. All of my information is there, and I'll have some cards over here as well. Thank you for coming.